February 2026 is bringing a complete transformation to the United States visa and immigration system, and if you're planning to apply for any visa category, have a pending application, or are already in the United States on a temporary status, what I'm about to reveal could fundamentally change your timeline, your strategy, and your entire immigration journey. We're talking about new rules that take effect in just weeks, processing delays that could extend your wait time by months, approval changes that shift which applications get priority, and enforcement mechanisms that will impact millions of people worldwide. Whether you're applying for a tourist visa, student visa, work visa, green card, or citizenship, these February 2026 changes will affect you directly. Some changes will benefit certain applicants while creating obstacles for others. This isn't speculation or rumor. These are verified policy updates from official government sources that you need to understand immediately. Stay with me because the next several minutes could save you months of waiting and thousands of dollars in wasted effort. Welcome back to my channel, where I bring you the most comprehensive, accurate, and timely information about United States visa policies, immigration law changes, and practical strategies for successfully navigating one of the world's most complex immigration systems. Today, we're covering the massive February 2026 visa and immigration changes that are already beginning to reshape how applications are processed, how interviews are conducted, how decisions are made, and how enforcement is prioritized across every major visa category. These aren't minor technical adjustments buried in regulatory footnotes. These are substantial policy shifts that will directly impact processing times, approval rates, documentary requirements, and the overall experience of anyone interacting with the US immigration system. After months of policy development, interagency coordination, and system upgrades, multiple federal agencies, including the State Department, Department of Homeland Security, US Citizenship and Immigration Services, and Customs and Border Protection are simultaneously implementing coordinated changes that represent the most significant overhaul of visa and immigration procedures in years. Before we dive into the specific changes affecting each visa category, the new processing timelines you need to know about, and the practical strategies you must implement to succeed under these new rules, I need you to do 3 essential things. First, subscribe to this channel immediately and turn on notification alerts so you never miss critical updates that could affect your application timeline or legal status. Second, hit that like button right now to help this vital information reach more people who are navigating the immigration system and desperately need accurate guidance. And third, share this video with anyone you know who's planning to apply for a US visa, waiting for an immigration decision, or living in the United States on any temporary status, because understanding these changes could be the difference between approval and denial. In the comments below, let me know which visa category you're applying for or which immigration benefit you're seeking, and whether these February 2026 changes will help or hurt your specific situation. Your real-world experiences and questions help build community knowledge and ensure everyone benefits from shared information. Now let's examine exactly what's changing in February 2026, why these modifications are being implemented, which applicants will benefit most, which ones face new challenges, and most importantly, how you can adapt your strategy to maximize your chances of success. The first major change rolling out in February 2026 is the dramatic expansion of digital filing and online processing across multiple visa categories. For years, applicants have struggled with paper-based systems that required physical mail, created opportunities for documents to be lost, and added weeks or months to processing times. Starting February 2026, USCIS is mandating electronic filing for nearly all major application types, including Form I-485, Adjustment of Status Applications, Form I-751 Removal of Conditions Petitions, Form N-400 Naturalization Applications, and most employment-based and family-based petitions. What this means practically is that you'll create online accounts, upload documents digitally, pay fees electronically, and receive notices through secure online portals rather than waiting for physical mail. The benefits include faster initial processing, immediate confirmation of receipt, ability to track your case in real time, and reduced risk of lost documents. However, there are challenges. The digital systems require reliable internet access, technical literacy to navigate the portals, and the ability to scan and upload documents in specific formats. For applicants in rural areas with limited internet or elderly applicants who aren't comfortable with technology, this creates genuine barriers. The State Department is also expanding online visa applications through the DS-160 and DS-260 systems, with new requirements for digital photograph submissions, electronic document uploads, and video interview capabilities for certain visa categories. While this modernization should eventually improve efficiency, the February rollout may experience technical glitches as millions of users transition to the new system simultaneously. The second significant change involves enhanced biometric collection and expanded security screening procedures across all visa categories. Starting February 2026, all visa applicants regardless of age will be required to provide biometric data, including fingerprints, facial recognition photographs, and in some cases, iris scans. Previously, children under certain ages and elderly applicants over certain ages were sometimes exempt from biometric requirements. Those exemptions are being eliminated. Additionally, the security screening process is being expanded to include more extensive social media review, employment history verification going back further in time, and enhanced interagency information sharing between immigration authorities, law enforcement, and intelligence agencies. What this means for applicants is that you should expect longer processing times for background checks, more detailed questions about your online presence and social media activity, and potentially requests for additional documentation about your employment history, travel patterns, and personal associations. The security enhancements are particularly impactful for applicants from certain countries or regions, applicants with complex travel histories involving multiple countries, and applicants working in sensitive industries or fields. If any aspect of your background triggers additional review, what might have been a straightforward approval could now take many additional months. The third major change is the implementation of a revised processing priority system that fundamentally changes which applications get processed first. Previously, most applications were processed roughly in the order they were received, with some exceptions for emergency situations. The February 2026 system introduces multiple priority tiers based on several factors, including the type of application, the applicant's current status, humanitarian considerations, and national interest determinations. Under the new system, highest priority will be given to applications involving immediate relatives of US citizens, particularly spouses and minor children. Applications related to employment in shortage occupations, particularly healthcare, STEM fields, and critical infrastructure will receive elevated priority. Cases involving documented humanitarian factors such as medical emergencies or safety concerns will be expedited, and applications from individuals already in valid status in the United States will generally be prioritized over applications from individuals outside the country. Conversely, lowest priority will be assigned to family preference categories with longer wait times, such as siblings of US citizens and adult children of permanent residents. Applications with incomplete documentation or those requiring extensive requests for evidence will be deprioritized, and applications from individuals with prior immigration violations, even if those violations have been addressed, may face slower processing. What this means practically is that your position in the processing queue is no longer determined solely by when you filed, but by multiple factors, including your relationship to the petitioner, your field of work, your current location, and your compliance history. Two people filing the same type of application on the same day could see dramatically different processing timelines based on these priority factors. The fourth significant change involves stricter documentary requirements and more rigorous evidence standards across all application types. Starting February 2026, USCIS and consular officers are being directed to require more comprehensive documentation upfront, reducing their use of requests for evidence. While this might seem positive, since it reduces back and forth communication, it places a greater burden on applicants to anticipate what evidence will be needed and submit everything with the initial application. For family-based applications, this means more extensive proof of bona fide relationships, including detailed timelines, photographs spanning the entire relationship, evidence of joint financial responsibilities, and sworn statements from multiple witnesses. For employment-based applications, this means more detailed job descriptions, educational credential evaluations, evidence of the employer's ability to pay the offered wage, and documentation of recruitment efforts. For student visas, this means more comprehensive financial documentation, detailed study plans, evidence of ties to the home country, and explanation of how the education relates to career goals. The challenge is that the specific documentary requirements aren't always clearly spelled out in advance, and what's sufficient for one officer may be deemed inadequate by another. This subjectivity creates uncertainty and makes it difficult for applicants to know whether they've submitted enough evidence. The fifth major change is the expansion of interview requirements for visa categories that previously could be processed without in-person interviews. Starting February 2026, many applicants who previously qualified for interview waivers will now be required to attend in-person interviews at US embassies or consulates. This includes certain visa renewal applications, dependent visa applications, and some adjustment of status cases. The stated purpose is enhanced security screening and fraud prevention, but the practical impact is significant delays in processing and increased costs for applicants who must travel to consular locations. For applicants living far from the nearest US embassy or consulate, this can mean expensive travel, overnight accommodations, and time away from work or family. Interview scheduling backlogs at many consulates mean that even after your application is approved, you might wait months for an interview appointment. The sixth change involves substantial fee increases across most application types and changes to the payment structure. USCIS has announced fee increases averaging 20 to 40% for most forms, with some categories seeing even steeper increases. The stated justification is recovering the full cost of adjudication and funding technology improvements, but for many applicants, these increases create genuine financial hardship. Additionally, the payment structure is changing to require full payment upfront for all associated fees rather than allowing staged payments. For complex applications involving multiple forms and family members, the total upfront cost can now reach thousands of dollars, creating a barrier for lower-income applicants. The seventh significant change is increased scrutiny of public benefits usage under strengthened public charge rules. While the specific public charge regulations have evolved over recent years, the February 2026 implementation emphasizes rigorous evaluation of whether an applicant is likely to become primarily dependent on government support. Officers will examine not just current income and assets, but education level, employment history, health status, age, and family size to make predictions about future self-sufficiency. For applicants who have ever used public benefits, even legally and appropriately, this could create obstacles. The burden is on the applicant to demonstrate, through extensive documentation, that they will not require public assistance in the future. Let's summarize the 7 major changes coming in February 2026. First, mandatory digital filing and online processing for most applications. Second, enhanced biometric collection and security screening. Third, a revised priority processing system that changes queue positions. Fourth, stricter documentary requirements with higher evidence standards. Fifth, expanded interview requirements for more visa categories. Sixth, substantial fee increases and changed payment structures. And seventh, increased scrutiny of public benefits usage under public charge rules. These changes reflect several policy priorities, including modernization through technology, enhanced security and fraud prevention, more efficient resource allocation through priority processing, and emphasis on self-sufficiency among immigrants. While some changes will improve the system long-term, the February 2026 implementation period will likely involve technical problems, processing delays, and confusion as applicants and adjudicators adapt to new procedures. If this video helped you understand the February 2026 visa and immigration changes, please hit that like button and share it with anyone navigating the US immigration system. Subscribe to this channel and turn on notifications because I'll continue bringing you updates, detailed guides for specific visa categories, and practical strategies for success. Drop a comment below with your questions, concerns, or experiences with these new rules. Thank you for watching. Stay informed about the policies that affect your immigration journey and I'll see you in the next video with more essential immigration guidance.